Hello, everyone. I'm Michele Shuster with McMurray and Shuster, and I'm here with my partners, Josh Stevens and Helen McMurray. And we are very excited to give you our annual predictions webinar, and this one for obviously 2025. So many things have happened in 2024, and I think it's foreshadowing a pretty active 2025. So hopefully we can break down what some of those issues are that we should anticipate and hopefully give you the opportunity to be proactive in addressing those. With regard to the webinar today, there's the ability to submit questions, and we'll get to those at the end of the webinar. If we don't get to them at the end, then we'll respond to you in writing to those questions. Also, this is being recorded, and the session will be available likely sometime mid next week in order for you to download and share with all your family and friends over the holidays. So let's just dive right in, Helen, and let's start with you on the federal landscape. What are you anticipating, especially with the FTC?
Sure. Well, let's start looking at it from a broad perspective. Just a few days ago, President Trump announced his 2025 consumer protection agenda, which is really primarily coming out of the Federal Trade Commission. And quite frankly, it sounded very aggressive for a conservative Republican. He wants to target fraud. He wants stricter digital marketplace oversight, and also more oversight with regards to privacy violations. And you'll hear a little bit more about privacy later on this hour. He also talked about bolstering the enforcement mechanisms in the agencies, as well as addressing corporate violations, and quote, he's going to hold businesses accountable. So that's kind of what you typically hear from a more liberal office holder. So most of this, like I said, will be out of the FTC, and we know that Andrew Ferguson is going to be elevated to the chairperson of the FTC. And we also got a little bit of insight from him yesterday. He had a dissenting opinion that I'll talk about in just a second. But Trump indicated that he wants to expand the enforcement powers of the Federal Trade Commission. And I think this ties back to what he was talking about with regards to bolstering the enforcement mechanisms, because he thinks that the FTC needs to really start investing in their investigatory tools that they have. And certainly I'm sure he's thinking about AI with regards to identifying that and seeing what's going on out there behind the curtain, if you will. Interestingly, he specifically calls for increasing penalties for fraudulent conduct. And I don't know whether he looks to do that statutorily or not, but that's how he would have to do that. And he also wants to streamline pathways for consumer complaints, which I thought was also very interesting. The FTC does keep some pretty comprehensive consumer complaint databases, but they are very tight-lipped with it. There's a couple of workarounds I have to be able to get consumer complaints, like on companies I'm representing. But for the most part, yeah, the Federal Trade Commission will not give that out. It's not available online. And there's basically, law enforcement only kind of attitude with regards to that. So I'm not sure how he's going to go on that. But I know when you and I were in the Ohio Attorney General's office, I think by the time that you were chief, all the consumer complaints were online, right?
Yeah, they were all online, and they were all shared with the AGs at least twice a year. And so while the FTC hasn't been very forthgiving of those complaints publicly, which is probably a good idea, because a lot of times we call them complaints, and there's the thought that those complaints mean that there's a violation of the law, and that is, I would say, typically not the case with a lot of those types of things. So it is a good thing that it's not public. The one exception to that is that the FTC does keep a public database of phone numbers about which consumers have complained of receiving calls in violation of the law because they're on the do not call list. Or some type of regulated technology was used, or an internal do not call request wasn't received or was not honored. So that is probably the one exception to where they don't make those types of complaints available. And most companies are using those to do robocall mitigation and to make sure that they're not running into issues that they weren't aware of.
Yeah. President-elect Trump also spoke to what we call UDAP, unfair and deceptive acts or practices. And his comment was that he needs to protect the public from them. And he found that that's going to be a key to maintaining and establishing a robust economy. So very big picture views that he has here. Some things that were more specific that he talked about was the prevalence of counterfeit goods and data breaches, and I think that that's tied with the his prioritization of really monitoring that online transaction world that's out there. That seems to be a kind of recurrent theme with regards to what he's been discussing.
Yeah.
He wants to be calling for mandatory third-party seller verification and enhanced transparency in advertising. And so those have been kind of the main things that he and his transition team have been talking with. Now, one thing I will also say, though, is that all of this is going to happen even more slowly than it did the last term, which was pretty slow, because the President Trump's transition team has to enter into these written agreements with the Biden administration agencies in order to be sharing information. And then there's a whole issue of background checks and confidential information, that type of thing. And that has literally just been sewn up in the last couple of days. So they're about a month behind, unfortunately, with regards to getting into these agencies, understanding what's going on, and being able to get up to speed very quickly. So that's going to be somewhat problematic. Although with the FTC, you've got an existing commission member who's being elevated to chair, and so that will definitely help, I think, from that perspective. So speaking of the chair, yesterday the FTC issued and approved the junk ticket and hotel fee rule. Right. And certainly I think we can say that junk fees are going to be a hot topic next year with regards to a number of different areas. And so the Commissioner Ferguson's dissent was not substantive. Basically, it was a posturing, if you will, of the to expect from the Trump regime. He said that he's going to end the 4-year regulatory assault on businesses that the FTC has been engaged in. And his primary objection was for a lame duck commission to adopt a new rule. And he then referenced the junk fee rule for tickets and hotels, and indicated that the original version of the rule, when it came out for comment, would have hindered economic growth and would have actually ended up costing consumers significantly more money because of the costs that businesses would have to incur to comply with it. But it sounds like he's pretty in for the new rule. So if he is substantively good for that role, then you're going to expect to see enforcement in those particular areas. So that's going to be something that you'll have to look at substantively if it's part of your industry. The last rule I'll talk about, and last thing with regards to the FTC, is the negative option rule. So we've been getting a lot of questions. Is that going to, what's going to happen with that? And so right now, it has been adopted by the commission. And there are at least 2 circuit courts that are evaluating it for whether or not it the passage of the rule and the contents of the rule comply with the FTC rules and appropriate laws and regulations. And so either of those 2 courts at any time could rule in its favor or oppose it or revise it. There's an interesting provision of the law that actually allows the FTC in the middle of the court action to submit additional information in support of, arguably in support of the rule, but it also could be that they ask for the rule not to be adopted, basically to withdraw it. So there is a provision in their enforcement powers for them to be able to do that. Also, the commission could always call the rule back up and use that process with regards to changing it if it found that was what it wanted to do. But I'll say, and tell me if you agree. But once these rules get running, and the FTC gets going with them, it's hard to stop the momentum because consumers will start to see the changes, and it'll be a little bit harder to roll it back. Versus, for example, like when Trump pulled out the payday lending rules, which really had not gotten up and running the first time around. Yeah. So, negative option, the junk fee rules. I think that these things are going to certainly be something that are likely to be dealt with a great majority of next year. And all it takes, is just, with millions of people visiting these sites, it doesn't take more than one little investigation to turn into something really huge. So, so that's kind of thing where we're going to see the FTC rule process go.
It was interesting this year in that we had the federal agencies challenged more than I think we had in recent years with the FTC's abolishing non-compete contracts you know, that was set to go into effect and it will not. And so we did see a change there with the FTC. Ironically, this morning, there was oral arguments on the Insurance Marketing Coalition's challenge to the one-to-one consent rules that the FCC passed that redefined prior express written consent under the Telemarketing Consumer Protection Act. So it is interesting that we do see more organizations, we see more companies that are challenging this aggressive rulemaking that's happened over the last 4 years. Really, it'll be interesting to see how those turn out, but there has been some success with, you know, the non-compete contracts as an example of that. So speaking of lots of developments in 2024 that we anticipate going into 2025, Josh, the state privacy laws have just been on fire this year. And you look a little tired, I think, as a result of that. Good, but a little tired. So give us an update on what you think is going to happen in 2025 with privacy.
Yeah, I think we've been going gangbusters since 2020 on the state privacy laws, right? I mean, it's been continuing, and we're up to 19 states that have passed comprehensive privacy laws so far. Not all of them are in effect yet. There are a variety coming into effect in 2025 and some in 2026, and they have nuances between them. The good news for anyone watching who needs to deal with these laws is, for the most part, they've coalesced around what I refer to as the Colorado-Virginia model. If you recall from probably webinars we've done in years past, there are two main frameworks: the California framework under the CCPA, and then the Colorado-Virginia. Some refer to it as the Washington model, because while it never passed Washington, that's really where it started. And they're largely aligned, but have some unique issues between them. But the Colorado-Virginia model seems to be taking hold. But there are fascinating developments that are occurring. Just one that immediately comes to mind, which is actually a 2026 problem, because it's January 1, 2026, but means it's a 2025 problem in terms of getting ready for it, is publishing the list of all third parties to whom you sell personal information on your website. So not just having that as something in the background that maybe you give a consumer if they have a request. So in terms of what 2025 is going to look like with state privacy laws, we need to get in compliance with the ones that are here, but I bet we're going to see more. My guess is, and we'll see if I should go to Vegas or not, is 5 more. I'm going to guess 5 more states, and
Write it down, Josh.
And I'm going to say that New York is one of them. I think New York is kind of the last of the big states that hasn't passed one yet. You could argue whether Florida's really is a comprehensive privacy law or not, because it has a really high threshold for applicability. But I think New York is going to close that gap in 2025. So let's see what happens there. And that's really where I see the action next year. This year we had the Kids Online Safety Act, which worked its way through the Senate, got to the House. Speaker Johnson has said it's not going to get a vote in the lame duck. And, you know, it may get reproposed next year in Congress, but I'll put that at 50-50, whether that happens. I think this Congress is going to have a lot on its hands in terms of President-elect Trump's regulatory agenda and tax cuts, border security, all those areas that he campaigned on that now he's going to need legislative action. It's probably going to eat up a lot of the bandwidth, especially in the first year of the congressional term. There has been discussion about a comprehensive federal privacy law that's not just for children. That has never made it out of a chamber yet. I don't think it's even made it out of a committee yet. And with the changeover, I just don't see that happening anytime soon. What I think will be interesting, and Helen, to your point about the FTC and President-elect Trump's regulatory agenda for the FTC, is if the FTC decides to try to fill that void, either through stepped-up enforcement of their existing UDAP authority in the world of privacy, which we've seen exercised previously with data breaches and what I might call gross deception kind of issues. They recently have had a few more cases where they've gone after companies for using data in ways that weren't anticipated by consumers or collecting data that wasn't anticipated by consumers, again, within that sort of deception world. So it'll be interesting to see if the FTC tries to close this gap by stepping up that enforcement during Trump's presidency, or if they actually try to engage in a rulemaking and set a national framework.
So Josh, I know one of the questions we had before our webinar started was, is any of this state, federal, everything coming at me going to get any easier? And certainly federal preemption for privacy would make a whole lot of people happy. Is that consulting the crystal ball? Anything that you think that might try to make
Consulting the crystal ball, if the Republicans in the Senate who have worked on a federal privacy bill in the past can push that forward, they were in favor of preemption. And I think that is the only way that this gets simplified, is if there is federal preemption. But there was very strong opposition to that, particularly from the California delegation in the House. And without the California delegation, given the tight margins, you're not going to get it through. So I think we're still going to be at a stalemate in 2025, unfortunately. And the best hope that I can offer is the fact that states are largely coalescing around this other model, around the Colorado, Virginia model, and get good counsel. And watch the dark circles under my eyes continue to grow over the next year. So it's going to be a fun year. I think the other area that is going to be interesting is with enforcement at the state level. We haven't seen significant enforcement so far. California had 2 enforcement actions that levied penalties over the past couple of years. We have seen Texas, under their general UDAP statute, filed a lawsuit against GM for some alleged data privacy practices with vehicle data. We know from public statements from Texas and from California that they have launched investigations into a variety of areas. And I suspect in 2025, that's when we will start to see those result in AVCs, settlements, orders, and so forth.
Yeah, I think that's going to be pretty aggressive too. I suspect we're going to see a lot of action. And I think, I don't know, I think it might be a little bit of California and Texas trying to outdo the other.
Yeah.
I think there might be a little bit of that. It certainly does feel like that with the filings we've been seeing lately from Texas and California. So I think that crystal ball is agreeing with you on that.
Yeah, well, and it may not just be them, because we've also seen some clients get letters from Oregon. Oregon has a privacy law now. We've seen them put out some you can do better letters to some folks. And Colorado as well is continuing to tweak its regulations. And as it does that, I suspect we'll start to see enforcement rolling out from there. So it'll be an interesting year.
Yeah.
Yeah, I wonder if, with regards to the consumer complaints we were talking about, because the state AGs, and we'll talk about them more later, but they're very consumer complaint driven. And a lot of the privacy violations, I don't think consumers realize that they're happening. I mean, I think that contributes.
I think that certainly contributes. And where we have seen Texas and California be interested in particular areas has been when things have come out in the press. So when news articles have come out talking about data use or data collection that consumers may not expect, and then that spurs. Because to your point, Helen, a lot of times consumers would have no idea that this is going on.
Yeah. Privacy is definitely going to be an interesting area. Well, Josh, are we ready to start talking about the TCPA, telemarketing types of issues? Because there's really not much going on there.
Well, nothing at all. Yeah, nothing at all
Yeah.
with that.
Of course, I'm being facetious there. This has been a very active year with regards to case law and rulemaking, especially with the FCC, but even the Federal Trade Commission implemented new requirements for the telemarketing sales rule. They increased the keeping requirements to 5 years for most of the records that you're required to keep, and also put forth very specific requirements of what call detail records must contain for those records that you're now required to keep. So I suspect that we will see the FTC make a statement with these revisions to the TSR. And you know how that will likely happen is they issue a civil investigative demand to a company not able to produce records. And it's something that I suspect we will see. Also, you know, the Federal Communications Commission with their one-to-one consent rule has significantly changed what the legal landscape looks like for the lead generation space, but also the sellers that are using the lead generators to produce information for follow-up text calls. As a result of that, I suspect that we will see a pretty significant increase in litigation next year. And so talking about those one-to-one consent rules, for anybody who has been living under a rock for the last year, you know, what we're talking about there is the FCC, starting on January 27th of next year, will require that consent be from one consumer to one seller. There are ways that the FCC has said that you can get consent from multiple sellers. One of those being if you have a checkbox that's, did we just go black there for a minute, Josh?
You were fine. You were fine on my end. I think you started
Okay.
talking about checkboxes and the computer just decided, you know.
It did not like that. So I do see something going on in the back. So if we were interrupted there, I apologize. But as I was saying, the FCC did provide additional ways that consent could be had for multiple companies, but it requires the consumer who's providing the consent to actually check each seller that they are providing consent to you know, individually check each one of those.
Yeah, and looks like we may have a technical difficulty, so I'm going to pick up from there and just talk about where I think that the litigation is going to really emerge, which is with regard to what does it mean to be a seller under the TCPA, and also with regard to when prior express written consent is really truly needed. For the longest time, the concept of prior express written consent, which technically appears in the rules for ATDS or automatic telephone dialing system and pre-recorded or artificial voice communications, has been conflated. All right, do we have you back? I was just going into the distinctions between PEWC and prior express invitation for DNC.
Yeah, I think we are back now. I'm not sure what happened there. Are the fates conspiring against us to share what's going to happen in 2025?
Too close on, and they were like,
Yeah.
you know, it's like, ooh, their crystal ball is working today.
I can honestly say I've never had that happen in a webinar in the years and years. Anyway, but thank you, Josh, for carrying the torch. And is there something,
Yeah, so I'll just wrap up
Yeah.
my thought, which is
Yeah.
what I was saying is I think the area where we're going to see the most litigation is going to be on the concept of a seller, because
Yeah.
that's going to be critically important now under PEWC. And then also on whether PEWC is truly required or not, because technically under the rules, it applies to the use of an ATDS or artificially pre-recorded voice. And for do not call compliance, it's a slightly different standard of prior express invitation or permission that has a different definition. And so it'll be interesting to see if courts try to take the PEWC requirements and sort of push them onto the PEI requirements for DNC compliance.
Yeah, I agree. I think that case is coming, and it's coming quick. And I also think that, you know, because the FCC said that with that new rulemaking, they were not changing the requirements for do not call consent or prior express invitation. It means that that rule will have always required that the consent have been obtained in that way, and whether that's one-to-one. And if so, you know, there's no waiting until January 27th to file those complaints. Those can start pretty immediately. So I think we will see challenges around what the definition of prior express invitation is. Also, you know, we all after Facebook versus Duguid, which defined what an automatic telephone dialing system is under the TCPA, the Supreme Court was pretty clear that they were talking about the random and sequential generation of telephone numbers. But the plaintiff's bar is really trying to push that they weren't talking about just telephone numbers, that if you are using a random or sequential generator in a way that predicts how those calls will be made, that potentially there's an argument there because that random and sequential number generator may be used to store or produce telephone numbers. And so it's something that we're already seeing out there. We do know that the circuit courts that have looked at this issue already have all universally agreed that it must be the random and sequential generation of telephone numbers, but it's probably worth it to have your dialer looked at to make sure that you have a defendable position that is not an ATDS. Because as Josh said, if it is, then every call that's made using that dialer requires this one-to-one consent, the prior express written consent, and that it be logically and topically related. So it just leaves you open for, potentially more causes of action, lawsuits, and a more difficult time winning those. So make sure you do know that your dialer is not an ATDS, and you have a defendable position immediately, so you can, work to get these cases dismissed or resolved immediately based on that defendable position that you have. So kind of moving on, somewhat related though, this morning, as I said, the Insurance Marketing Coalition had their oral arguments on their challenge to these one-to-one consent rules. And the IMC is, challenging the FCC's ability to have implemented these rules, and also the impact the rules have on small businesses and whether the FCC properly reviewed those. And so we will be seeing a decision on the IMC case. It was expedited. Some are predicting that we will have a decision before the January 27th date when these new one-to-one consent rules go into effect. There is no guarantee of that. And the FCC last month in their open meeting said that the rules will be going forward and that is on January 27th. And that's regardless of President Trump now being in office in a Republican controlled FCC with Brendan Carr as the chair, who is a Trump appointee from Trump's prior term. So, we need to anticipate and we need to plan that the rules will go into effect. In talking to the folks at IMC, I think they're probably putting their chances of winning around 30 or 40%, which is not horrible odds, if accurate. And they did get a really great draw from the circuit court where this is being, or the court where this is being heard today. They were all prior Trump appointees and seem to, maybe be open to hearing those challenges to the new rules. So I would plan on those going into effect on January 27th, but there is still some hope out there. Josh, what do you think about the Do Not Disturb Act? That's one that's been out there for a while that would change calling hours to 9 o'clock. You can't start until 9 o'clock. And I think they end at 5 o'clock under the new rule, right? It'd be 9 to
I don't recall off the top of my head.
See, I'm putting you on the spot here, but it did shorten those allowable calling hours and define the types of calls that are restricted in a more closed way.
Yeah, and it's that one is kind of interesting because the sponsors of the bill are folks who have had success in the past getting telemarketing regulations through, and we know that Senator Thune, who's always had a keen interest in this area, is now going to be the majority leader in the Senate, and that probably bodes well for getting it through. I do think we'll still run into the same problem that I talked about with the privacy bill of just a bandwidth issue within Congress. In the Senate, especially, we'll also have to be confirming all of the nominees for cabinet positions and those higher level political appointees. So probably there will be some bandwidth challenges, but I think that's an act that potentially has some runway for passage.
But Josh, one of the things that I remember with regards to, that 5 p.m. or the evening time, is with regards to door-to-door solicitations and trying to get people not knocking on your door when it's dark at night. And there's actually a very robust, case law on that. And the U.S. Supreme Court applies a strict scrutiny in terms of its review. And it's really very difficult to get past just a flat, 5 p.m. or 6 p.m. I was actually an expert witness in a case that went up to the U.S. Supreme Court. And that was back when I was a regulator, and I was trying to show that it was in the evening, and it was a neighborhood disproportionately of senior citizens, and that's why the locality wanted to have no solicitations after 5 p.m. And the U.S. Supreme Court just struck it down and said, no, you can't do that. That's not enough of a good reason. Folks, even commercial speech has the ability to be out there and say they're getting to that audience after people have been at work all day.
Yeah, and what I think will be interesting is if perhaps they move from that angle towards what we're seeing happening at the state level, which is broadening back out that concept of an auto dialer, right? We know that Florida, Oklahoma, Maryland have laws in place now that define an auto dialer more broadly than an ATDS at the federal level. And so if Congress decides that, you know what, we're going to amend the TCPA and we're going to broaden back out that ATDS definition, our
Yeah.
world could change very quickly.
Yeah, we're back to the substantial human intervention days. What a nightmare that was, and what just a en masse of litigation that occurred. It's interesting too that the FCC will likely have less ability to define its own statutes or interpret its own statutes and regulations as a result of the Chevron deference being overturned by the Supreme Court in the Luper Brighthouse case. And that one was interesting because basically the Supreme Court said that the FCC does not have the ability to do those things that are limited to Congress's ability, which is to pass new laws. And they had looked at the Chevron deference, which allowed the FCC to provide interpretive rulings of what its statutes meant. And so it didn't have to go through the complete rulemaking process for some of those types of things. And an example of that is the prior express consent definition that's currently in the TCPA, although not yet being looked at again. That is something that the FCC did through an interpretive ruling. And what they said is if you are making informational calls to the regulated technology, using two cell phones using the regulated technology, that if the consumer has provided their telephone number as a means of being contacted and you're contacting them within that means, then you have prior express consent to place that telephone call. And so that's one that could be in danger as a result of losing the Chevron deference this year. And then kind of similar to Chevron deference, there's a statute out there. It's called the Hobbs Act that allows the FCC to pass interpretive rulings, and the district court must follow those. They can still be looked at the circuit court level, and the FCC's interpretation could be overturned. But we all know that when you're involved in litigation, if you have to go all the way through district court, you've probably already lost just as a result of the legal fees. And so that's something very concerning to businesses out there. The Hobbs Act is being challenged in a couple of cases, one of which has been, and maybe more now, but at least one that's been accepted by the Supreme Court. So, based on their prior holding regarding Chevron deference, I think I would be willing to make a prediction that it's likely that the Hobbs Act will be overturned as well. And so less ability for the FCC to issue those types of interpretive rulings.
Yeah, I would, in fact, I'd probably put the odds of that at probably 70 or 80%.
Yeah.
I think this court has shown a strong willingness to overturn federal shall we say, zones of safety in rulemaking and say, you know what, it is the job of the courts to interpret rules, not the agencies. And I think I would say the odds are pretty good on the Hobbs Act.
Yeah, that's right. That's right. And Congress to create those, right? So that, that separation of power is still, that's in the Constitution, still means something, is what we're seeing this year, and we'll likely see next year as well. What about refer a friend type of campaigns, or the SEMA claims that are out there. That's something we saw a little action on this year.
Yeah, this is an emerging area.
Mhm.
Washington State has a pre-existing law referred to as SEMA that regulates the use of text messages. And I'm sure that probably all of us have at some point been offered the opportunity to have a text message created for us that we could send to a friend to connect them with a business. And these are often referred to as refer a friend programs. And businesses like these programs from a compliance perspective because the business isn't the one initiating the message. They're drafting it, dropping it into the messages app on the person's phone, and then the person from their own cell phone is sending the message. Well, we're now seeing some cases popping up in Washington saying that the creation of that message and dropping it in the person's phone is providing substantial assistance for the initiation of that message. And so it should be done in accordance with this law that requires consent for those messages. And it's been a kind of a game changer for companies that engage in these from a risk perspective. And so if your business, anyone watching uses these types of messages, definitely take a look at these, consult with counsel about risk mitigation because they are getting these cases are getting traction.
Yeah.
And another area just before we fully leave the TCPA, that I think we're going to see more litigation in this coming year is on e-sign.
Mhm.
And just to remind everyone, prior express written consent is supposed to be done through a signed written agreement after giving certain disclosures. And the FCC has said if you're getting it electronically, it has to be collected in conformance with the e-sign Act. There was a case a few months back, Bradley v. dentalplans.com, if I'm remembering correctly,
Right.
that held that an oral recording. So if I were to, read Michele a PEWC disclosure, and then Michele says yes, and we capture that on a recording, that's not sufficient under the e-sign Act, that it needs to meet all the requirements of the e-sign Act, which are pretty laborious if you actually need to check all those boxes. And I suspect we're going to see in 2025 more cases alleging that PEWC was not acquired in conformance with the e-sign Act and therefore was invalid, and the calls or texts that were made in reliance on it therefore were in violation.
You think that folks are just thinking that, I'm relying on Adobe or some other platform to get the e-signature and that they're taking care of all those issues?
Well, I think if you're using Adobe DocuSign, you're probably in a pretty good spot because they have the e-sign disclosures and all of that built into their platform. Where I think the risk is coming in is the oral acceptance, and then web forms that aren't designed with e-sign in mind. And so don't have the
Just
e-sign,
pretty much all of them.
which is pretty much all of them. Yeah.
Pretty much all of them. Yeah.
This actually gets to a question that one of our viewers asked before the presentation started about, where's the biggest risk area in one-to-one consent? Is this going to be part of it since it's been tied right in there in the revised rule or statute?
I absolutely think so. Because if you look at the way the FCC talked about this, and this e-sign requirement, they actually mention in a rulemaking from 2012, I think it is. It goes back, but it never got attention. And what with this new case, I think this is going to pop off a lot of lawsuits.
Yeah. Yeah, that order was interesting, and that it said that, you shouldn't worry about these new requirements under the TCPA and having to get consent because consent is easy to get, and e-sign is easy to comply with, and so a lot of companies have relied on that, and that has been the history of how we collect consent under the TCPA. And typically you'll see a consent form that says I provide my electronic signature, and thinking that that's going to meet the e-sign requirements. But it really does. It requires an affirmative consent to the e-sign requirements and then affirmative consent to the actual TCPA consent language that you were agreeing to. And the FCC had kind of cavalierly said previously that it's easy to meet these requirements. Just a key press if you're doing it through a telephone or just a simple affirmative type of step. But that is not what AGs have filed comments on. Some courts have looked at this and it is something that we're definitely going to see litigation on in 2025. I think you're right. That will be a hot area. So that's one you definitely want to make sure you get right, because obviously if a consent form's not right, then every call you make, and this is for regulated technology and the one-to-one consent rules, but prior express invitation, consent for do not call, also requires a signature and a writing. So, it's one of those areas you want to make sure that you get those right. Let's see, anything else you know what, I did want to mention one other thing, just because this is something the FCC has released recently. And when the FCC releases these types of things, it usually means there's some kind of action that is going to happen. And here the FCC specifically threatened it. And that is, as most of you are probably aware, if you are working with a voice service provider, voice service providers are required to file something called a robocall mitigation plan in the federal robocall mitigation database. And that document must outline the steps that voice service provider or carriers are following to make sure that they are remediating any potential for illegal or unwanted robocalls, and also that they are going through a proper know your customer process when they're signing up those customers. Well, the FCC just did a thorough review of the robocall mitigation plans that were filed in the robocall mitigation database, and they found over 2,000 of those as being defective. And so they have sent notice to those service providers and said, you must file robocall mitigation plans that meet the requirements from the Trace Act and then the TCPA. Otherwise, we will issue a notice that you have not met the requirements to file with the robocall mitigation database, and the carriers will not be able to accept your traffic. So this is on the FCC's website. If you search robocall mitigation database under their press releases, you will see that. And you might want to make sure that your carrier is not in that list and not going to run into those issues. And if they are, you want to reach out to them pretty immediately and seeing about what they're doing to get their robocall mitigation plan filed. All right, so I think this takes us to AI and what we're seeing in AI. This is a hot topic. And I think that we are sure to see a lot of action here. We already are in 2024, that will continue in 2025.
Yeah, and just linking back to the TCPA, that's actually one of the areas where we've seen a lot of this action is folks not understanding that an artificial voice falls within that category of an artificial or pre-recorded voice that's a regulated technology under the TCPA. So when using AI for voice communications, you need that prior express written consent for marketing to cell phones, and that's a gap that we've seen emerge, and we've certainly been working with clients to close. With AI more broadly, obviously it's integrating itself into every facet of our lives, and with business, it's offering tons of opportunities for growth and efficiency, but that comes with risk, because you're delegating essentially thought processes to a computer system to make those decisions for you. And so in 2024, we saw, for example, California passed a law that beginning in 2026 will place requirements on generative AI developers to disclose more detailed information about how their systems were trained, how they function, what they do, and make that available publicly so that users of those systems have that understanding. Colorado, likewise, in 2024, passed a law that will be going into effect in 2026 for high-risk AI systems. So AI systems that make, for example, financial decisions or employment decisions. And so putting more parameters around that. 2025 is the year to get into compliance, right? To start working on that so that by the time 2026 gets here, you're ready. But even if those laws didn't exist, under privacy laws, your use of AI has to comply with privacy regulations. It has to comply with non-discrimination regulations. It has to comply with data security regulations. People tend to think of AI as a silo, but it's not. it's really a method, it's a tool that's used to make decisions or produce product that pings off of all kinds of different regulatory frameworks.
Yeah.
And
In talking with some of the state AGs with regards to AI and what their interest is, it's the disclosure that what you're purchasing as a consumer is AI or partially AI generated. So for example, think about a book that you buy on Amazon, they're basically saying that if this book was written or assisted by AI, that needs to be clearly and conspicuously disclosed to the consumer prior to purchase. So we're seeing that from that perspective. And then kind of getting back to what you talked about before, Josh, they're also looking at, when you're using AI as a business to improve your efficiencies, like we were discussing, you also have to look on the opposite side of that and say, are you harming consumers by doing that? Or are they getting a worse experience? Are they not getting all of what the law requires because you're focused on one side of it and not the other?
yeah, or do consumers know that they're interacting with an AI rather than a human? That's another area that we've seen pressure. And so in 2025, I think, if you are a business that utilizes AI, especially for interactions with consumers or in employment, you really have got to get your house in order, because the regulations are coming and enforcement is coming even under existing regulations.
Yeah, and that house in order, it requires that somebody be responsible for that AI. And I think that's the thing we see sometimes problematic in smaller businesses, not assigning a responsibility for managing the AI. Also, just the security of data. If you have health information that's protected or other sensitive or personal information, be it because you're an employer or because you have access to client information or those types of things, if you are working within an AI platform where your information is training that AI and that is available to others within that AI environment, then you are going to run into some issues with protecting that data that you're required to protect. So there are just so many areas, as you guys said, that AI hits. And it requires that you have those thoughtful policies and procedures in place and that you are training your employees so they understand, because a lot of it is even this, the phantom AI that your employees are using that you may not even know that they're using, and putting your sensitive business information into
Goes
that.
beyond the four walls of your business too, because you have to know your business partners, who are your vendors. And, so for example, we're seeing a lot of complaints now about possible use of AI for discriminatory practices with the door-to-door sales of things and the lender. So you're not the lender, but you've got a business partner who is the lender. And if they are using their AI uses discriminatory tactics, then that can come back on you as well, and potentially could be found to be unfair practice for you as well. So
great point. That's a really great reminder about due diligence on the vendors and third parties that you work with.
Weakest link.
Yes, we've seen a lot of cases around those types of things. Okay. Do we have access to the questions that have been asked?
2 questions.
Okay.
So I'll read and you all can answer or kick it to me. So first question: how do you foresee shifts in regulatory priorities impacting do not disturb laws, probably like the do not call laws, and social media compliance, social media advertising compliance?
Yeah, so interesting, right? So when you're looking at social media, you're looking at what type of messaging is available, and are those coming to consumers in ways that would implicate the TCPAs or state equivalent rules around text messaging and SMS and those types of things. So when you're looking at social media, and it's not just in the telemarketing regulations area, but also in the privacy area, you need to understand that a lot of those rules are going to apply, and you really need to do those same types of analysis that we've talked about here. So I think we'll be seeing a lot more around that. I also think President Trump, if we're talking about social media, very interested in big tech. I think that this administration will be coming down pretty hard on big tech, and I think that that President Trump wants to eliminate some of the protections that are currently there for these social media platforms and whether they're responsible for the content.
And the same thing you're seeing at NAG, which National Association of Attorneys General, they're indicating from their Consumer Protection Council that social media is going to be one of the top priorities for state AGs next year.
Yeah, yeah. And we saw the FTC last year, and this is continuing that for for influencers and those that are giving testimonials or endorsements that the proper disclosures are being made. If they're being compensated for that endorsement or that testimonial, that has to be disclosed. And then if that testimonial or endorsement doesn't accurately reflect what that product's characteristics and what it can and can't do, then you can have some liability around that too. What do you think, Josh?
I agree 100%. And I think the focus on big tech, and especially with minors, so people under 18 will be a big target in 2025. We've already seen Instagram roll out special teen accounts. And with multiple states, we didn't even talk about them, but with multiple states having passed age appropriate design code laws in 2024, I think you're going to see even a greater influence, a greater emphasis on how social media advertising is interfacing with minors.
Yeah, yeah.
Next question. What about consent to click wraps? This popped in while we were talking about e-sign. What about consent to click wraps? Will they have to be obtained pursuant to the e-sign act, or would a time date stamp with email be sufficient?
That's a great question for you, Josh. You have been doing so much of the click agreements.
Yeah. So not to get into too much detail, given we've got such short amount of time, but the e-sign act has very particular requirements for how you have to obtain an electronic signature when there are disclosures mandated by law to be provided to a consumer in writing. And that's really the trigger for those very detailed rules. If the disclosures are not required to be provided to the consumer in writing, then there's more flexibility in how you can obtain that electronic signature. So to the question here with consent to a click wrap, if that click wrap has information in it that is required to be provided in writing to a consumer, it probably needs to follow the full e-sign act requirements.
Yeah, yeah.
We also had some questions that we received before the session, and I think we've talked about a number of them because many of them related to one-to-one consent, and we've discussed one-to-one consent at length. But there's one that I think is really interesting here for your all's view, which is how can we rectify the FCC requirement that consent be given to a seller and the CMS requirement that consent be given to a TPMO, which by definition is a third party?
Yeah, and they're really two separate requirements under two different types of rules. CMS, we're talking about, Medicare and Affordable Care Act and those types of things. And this is something that the CMS has been all over for the last couple of years. And that is trying to get a handle on third-party marketing organization, i.e. lead generators. And so, the first thing they did was that they required that all insurance companies take responsibility for what the TPMOs, third-party marketing organizations, are doing. And then, more recently with revisions to the rules is to get authorization for a health insurance company to be able to contact them. And so there are some very specific rules around that. Having just ending now in the open enrollment period, I know that had been a very, very popular question. But as far as, if that is conflicting, I think that under both of those rules, you do have to get consent for the seller or authorization for the seller to be able to contact them. There are some additional rules under CMS that may require a 24-hour waiting period, but they are extremely detailed. This is an area you definitely want to make sure that you understand and that you are meeting all of these requirements, because they both do apply. The CMS rules do not trump the TCPA and vice versa.
Yeah, because I do know that they're talking about the permission of exchanging health information to that third party who's going to maybe fulfill some part of what's being provided.
Yeah, yeah. and that's what most of these lead generation forms are, and it would be the sharing of that information and
Exactly.
requiring authorization. So, yeah.
Another question just popped in, this one in my neck of the woods. So in reference to the state privacy laws, and my comment about mandatory publishing of the list of third parties to whom data is sold, is that only Rhode Island or multiple states? So Rhode Island is the only state so far that will require the list be published on your website. But multiple states now have the requirement that that list be available to consumers upon request. And so you don't have to necessarily publish it, but it has to be available to consumers from that state upon request. And all of the states with comprehensive privacy laws require fairly detailed disclosure of the types of businesses to whom you sell information. So even if you don't have to identify them by name, you do need to give enough information that a consumer knows the type of business and what they're likely to use that information for.
This is a great question to end with, I think. And Helen, this is, I think, a really good one for you. The question is, it seems Congress, many government agencies, and even states are all trying to solve the same problem, albeit not in the same way, which is why we are the queen of 50 state surveys, but in their own ways. And is there ever going to be, are these ever going to get simpler in compliance with all the states and the feds?
Okay. As long as we elect all these people, absolutely not. You know,
I don't think that's likely to change in
no, not gonna
2025.
happen, not gonna happen. You know, and I saw this when, so when I was back at the Attorney General's office, it was a good 20 years ago, and we brought the very first really big multi-state cases, tobacco and Microsoft, and all of these state attorneys general got all of this media attention, and it was very positive, Republican and Democrat, quite frankly. And so, you know, that's been their ticket going forward, and other elected officials have done the same. And so, and even like when you're working within the regulator community, state to federal, they have very vicious arguments with regards to preemption. And the states absolutely will not budge on it. They won't agree to anything that is going to preempt them. And that's why I think, you know, privacy for one thing, but many other, or changes to TCPA. I mean, there's just not even a halfway point that they can get to on that issue. Either you can or you can't. And one thing that I also learned is when I was negotiating cases with these 50 states, you know, where that was our team. Oh my gosh, we couldn't agree on anything. I mean, there are really, really huge differences in temperament between the states. And all you gotta do is look at a red and blue map of our country, right? And there's not a right or a wrong. It's just that we have all chosen to live together, and we have to find that middle road. And it creates this difficulty that our listeners is speaking of. And it's, I think when the problem is not being solved, like privacy, then it's going to get worse and worse. And then finally, I think they'll come in and get an answer, but I don't see it anytime soon, certainly. So
Yeah.
Sorry for a negative answer on that.
Yeah, no, I think you're absolutely right. And it's kind of the least common denominator.
Rule,
you know, we're going to apply with the most stringent of the requirements and apply it across all 50 states, or we are going to take a state by state approach. And to the extent, which is what we're seeing now, that the states are more restrictive than the federal government, then, you know, sometimes we're doing that in all 50 states, or we have to come up with a way that we can be very specific about what our marketing and business practices are in each one of those individual states, so we can meet the state and federal requirements. Because when these lawsuits are brought, very rarely is it only a federal claim or only a state claim. If there is the ability for plaintiffs' attorneys to bring federal and state and multi-state claims, then they're going to do that.
We talked about the negative option rule. There are several dozen states that have their own version of a negative option rule as well. And you're exactly right. Once this new federal rule comes, doesn't mean they're not going to include those state actions as well.
Yeah. Unfortunately, preemption is not. Preemption starts to limp probably a little bit more next year, even with canned spam. That for many years we thought the federal government had completely preempted states. We're seeing cases being filed in California around emails pretty frequently, actually, and getting private right of action for those consumers. So, all right, we are at the hour. You guys, always wonderful to present with you, especially the morning after our Christmas party. I think we all deserve A
pretty
pat on the
well,
back,
yeah.
yeah, after, a glass of wine or two last night. So thank you for joining us, and we look forward to seeing you on the next M&S webinar.
Happy New Year.
Happy New Year.